I'm happy to have the delightful picture of Rhonda up there. I don't have a PowerPoint, so we can either go with Rhonda or we can.
Yeah, Rhonda's good to look at. Let's stay with her.
Better than looking at me. Much of the discussion around AI appears to come from the henny penny school of rhetoric. For those of you from the United States, I understand it's called the Chicken Little School of Speech and Drama. It will destroy creativity. It will take our jobs, and we as lawyers are particularly prone to that last one. Indeed, it will lead to the sky falling in. And some of those things may be true. But I'd prefer today, if I might, to concentrate on the positives. I'm conscious that I'm focusing on only one side of the coin and that the negatives also deserve due attention. But what I plan to do is to set out a number of assumptions of what AI will be able to achieve in the near future and hypothesize the influence that each might have on design law. I've tried to take an international approach, although many of my examples will be drawn from the UK and the EU. So my three assumptions, where we start, are as follows. First, that AI will enable the generation of billions, if not trillions, of designs. Second, that AI will dramatically improve image recognition technology. And third, that AI will play an increasing role in decision-making. This session focuses on AI application and registration processes and eligibility, and whilst I will roam across a slightly broader landscape, let me try and tease out some of the innovations potentially coming down the pipeline and to suggest what impact they may have on design law here and abroad. And I'd like to thank Mark Davies and Robert Dickens for their assistance in preparing this talk. Any errors, of course, remain mine. In October 2024, Dario Amodei, co-founder and CEO of Anthropic, published an essay titled Machines of Loving Grace, How AI Could Transform the World for the Better. Amodei is important because Anthropic is one of the leading companies building AI models. His predictions are startling, particularly in the realms of science and healthcare. He considers that AI will be able to cure most diseases, including cancers and Alzheimer's, potentially within the next 12 years. He predicts that AI will give us the equivalent of 50 to 100 years of medical progress in the next 5 to 10 years. He sees the human lifespan doubling to 150 years. As an aside, the compulsory retirement age for judges in England and Wales was recently raised from 70 to 75, and on the basis of Amodei's predictions, I look forward to the next increase being to the age of 110. Amodei's essay self-consciously focuses on the positive, noting that fear is one kind of motivator, but that's not enough. We need hope. Thus, let us convene in hope and see where together hope might take us. Compared to his predictions, mine today will be remarkably tame. One general point before I start. The EU has just spent 10 years reviewing the 1998 Design Directive and the 2002 Design Regulation, passing amendments to both statutes last October. There is mention of 3D printing and future-proofing the legislation for technological developments, but no mention at all of AI. There is also currently open a UK IPO survey on design protection. It closes on Tuesday, so I would encourage you all to log on and answer the questions. There is just one on AI-generated designs, and it simply asks, should they be protected? Turning to my first assumption, and that is that AI will enable the generation of billions, if not trillions, of designs. In some senses, this is already with us. As I understand it, the algorithm for online website Shein calculates what is selling well and suggests new designs that should be put into production. A recent study calculated that Shein releases over 1.3 million designs annually. Another study suggested Shein adds 6,000 to 8,000 new designs to its website every day. And according to the same study, that's more designs in a day than high street retailer H&M produces in a year. So in some ways, this supercharged design powerhouse is already with us. But let us assume that AI takes things beyond clothing to impact furniture and motor vehicle designs, graphical user interfaces, and logos. A McKinsey study last year gave the example of industrial designers at an automotive OEM who needed just 2 hours with the help of AI to create the initial design concepts for 25 variations of a next generation car dashboard with a touchscreen interface, charging surfaces, instrument panel, and other components. So once again, some of my first assumption is already reality. And for the moment, keeping my positive hat on, and with apologies to Dr. Trepova from this morning, we need to put aside for now the question of whether AI-generated works are deserving of protection at all. Let's turn to the impact on design law. In the design field, having billions of new designs will likely narrow the scope of protection for most designs, because many areas of design will, in effect, become saturated with multiple very similar designs. This creates the squeeze. The allegedly infringing design needs to be closer to the infringed design than is any prior design. The more kindred prior art, as His Honour Judge Burse QC, as he then was, described the 54 prior designs in the Samsung and Apple tablet computer dispute, the narrower the protection afforded to a valid design. Rather, it will only be truly innovative designs that are entitled to clear blue water, that is, a broad penumbra of protection. I use that expression in the Court of Appeal's judgment in Procter & Gamble and Reckitt Benckiser, although that was not in fact what the court did in the end to the award-winning innovative sprayer design in that case, or indeed the, quote, innovative and clever, end quote, trunky ride-on suitcase some years later. In both cases, clearly correct decisions at first instance were overturned by the Court of Appeal. There is currently an interesting reference to the Court of Justice from the Community Design Court in Alicante in a case called Deity Shoes. The Spanish importer bought the shoes from China. The shoes had been manufactured on the basis of what are called sample books, where the Spanish importer chose from the book the colors, materials, placement of buckles or laces, anything you needed to design a shoe, and the manufacturer then made up the shoe accordingly. Some might call this design, even if it is a simple form of combining known features into a new product. The alleged infringer didn't seek to find invalidating prior designs, in part because we know from the Karen Millen case that invalidity is on the basis of a single earlier design, not an amalgam or mosaic of multiple earlier designs. Rather, in Deity Shoes, the referring court suggests to the Court of Justice that no design right should subsist at all because there was no author's own intellectual creation in the process of designing the shoes. That reference has not yet been decided, and it will be interesting to see what the Court of Justice does with it. But AI-assisted design, at least in its current form, does something not dissimilar. It takes known features and combines them in new ways. There doesn't seem to me to be any statutory basis for declaring that there's not enough for the design rights to subsist. And the Court of Justice will introduce into design law concepts from copyright law, such as the author's own intellectual creation, at its peril. Second, with many more designs being generated, we will continue to need a simple and cost-effective way to register those designs that the designer considers ought to be protected internationally. Currently, that process is fraught, even if using the Hague Agreement, which is the design equivalent of the Madrid Agreement for trademarks. It is highly unlikely that the set of drawings of the design that works here in the United Kingdom will be accepted elsewhere, causing additional costs and delay. And remember too that unlike trademarks, a design which fails at registration cannot simply be refiled because the disclosure of the design will render the later filings invalid. Therefore, IP officers should, in my view, be ready to grant a filing date to a design application with very minimum information, even if the validly registered design requires further details to be provided later on. Last November, after 10 years of sometimes impassioned debate, WIPO's member states agreed the Riyadh Design Law Treaty, which seeks to simplify and harmonize design filing practice around the world. Importantly, the treaty provides for a closed list of requirements which a member state can make of a design applicant. This is a very good start. The treaty has been set up to enable those member states that eventually accede to amend it more easily, so that the list of requirements can be reduced. Multilateralism is difficult, and it's getting harder. This treaty is a significant success, and AI makes it even more important, particularly for small to medium-sized enterprises and individual designers. I turn now to my second assumption, that AI will dramatically improve image recognition technology. As Dr. Cobb mentioned earlier today, currently the technology is available to detect a known individual as he or she moves through a crowded railway station or airport. Facial recognition software can't tell identical twins apart, but it is pretty good at finding most of us. However, we don't currently have the technology to detect other sorts of objects more common in the design field, such as furniture, for example. The proof is to be found in those online requests to prove that you are a human by finding the images within the frame of 9 squares that include a crossing, a traffic light, or a motorbike. But what will the impact be on design law if software is able to find for you in an instant all the known images of products which create the same overall impression on the informed user as, say, a table or a jacket which you upload? Currently, searching for invalidating prior designs is slow, often manual, depressingly incomplete, and expensive. Some wag once said that legal advice can be quick, cheap, or right, but it can't be all three at once. With searching for prior designs, it's very often not quick, not cheap, and not right. AI will revolutionize that, and what impact will that have? To be clear, AI is already involved in searching. The EU IPO uses AI for its trademark search tool, and it also announced in 2003 that AI will be added to its design search tool. So again, this assumption is by no means far-fetched. For a start, affordable and accurate searching will make clearance searching affordable and accurate, which may encourage traders to take it up. Currently, many designers don't bother because the level of comfort is low for the high cost. This is particularly true in a world that has unregistered design rights, such as here in the United Kingdom, where they can last for up to 15 years. Inexpensive, accurate clearance, currently available for traditional types of trademarks, may see a decrease in accidental design disputes. Second, I can also see a world in which accurate searching may see relative grounds examination reintroduced in the United Kingdom. This trend has been against us, largely because it slows down registration, wastes resources, and intellectual property officers are currently poorly placed to do accurate searching. Changing just this last variable, particularly if combined with AI-assisted decision-making, to which I'll return in a moment, means that relative grounds examination could be reintroduced in the UK, as it has been maintained all these years in the United States. Designs which are obviously invalid will be kept off the register inexpensively and efficiently. This increases with importance with the results of my first assumption, that is, that there will be significant increase in the number of designs generated. Third, readily available design searching will create a new revenue stream for designers, currently available primarily to photographers. Any of you in private practice will have had a pro bono request from a local sports club or parish council, which has received a letter before action from a collective management organisation or image library, asking for often a not insubstantial license fee for an inadvertent use of a copyright-protected work on their website. Bots crawl the web to identify photographs, and AI will enable the same bots to seek out an infringing vase, fork, or dress. Designers might also consider watch services, as we currently have for trademarks, to monitor what's being filed around the world. What is currently impossible may quickly become routine. Fourth, might good searching also lead to the death of the Locarno classification? For design geeks amongst us, the Locarno classification is a taxonomy which places every known industrial or handicraft item into 32 classes. Bottles are in class, anyone? Bottles? 9.02. Windmills are in class 2503. Fire trucks are in class 1213. While such a classification is necessary now to enable traders to find prior designs on the register, it won't be necessary when a search facility is available to do it. either through uploading an image or even a simple word-based search prompt. Hey Siri, please find me all the images of windmills on the EU IPO design register. Currently, a designer seeking to put a fire truck on... Sorry, what was that? There we go. Let us know the results. Currently, a designer seeking to put a fire truck on, say, children's pajamas will need to search each class where an image of a fire truck might appear, such as pencil cases, which are in class 3.01, traffic signs in class 10.06, and surface patterns in class 32.01, as well as actual fire trucks. The expense is prohibitive. As an aside, I worked some years ago with the WIPO Standing Committee on Trademarks, Geographical Indications and Industrial Designs to try to come up with a word-based classification that could overlay the Locarno classification system by providing greater specificity. At a working group meeting in Prague, we started with tables, what we thought would be the simplest of furnitures. But we quickly got bogged down in two-legged tables versus three-legged tables versus four-legged tables, let alone their height, shape, color, or materials. Our attempt failed because there are just too many variables to describe in words. I also recall a heated argument over whether unicorns should be classified as animals or mythical beasts. That might be a story for another day. What's true for the Locarno classification is also likely true for the Vienna classification for device trademarks. We won't need it once we have decent image recognition technology. I've also recently been rereading the EU design approach, an excellent work edited by Annette Kerr, Marianne Levin, and Jens Schobsvo. It was in the context, and here I apologize for the shameless plug, of drafting the third edition of my own book on design law, due out from Oxford University Press in November this year. The EU design approach is a useful reminder of just how revolutionary EU design law was in 1998, particularly in not attaching a design to any particular product, either for registration or enforcement. In the UK and EU, a registered design for a car door handle can be used to prevent the sale of an infringing boat handle, or indeed any object that creates the same overall impression on the informed user, whether it be a vase or a knife. Similarly, it could be invalidated by a prior design from any sector. That is not true in much of the rest of the world. But might advances in visual recognition technology, fifthly, see a global move towards the UK-EU position, whereby a design protects against any use in any product? If it's possible to find any product design or any prior design similar to a tablet computer, whether it's a computer monitor, an Etch-a-Sketch, or a movie prop, does it continue to make any sense that design protection only protects products in the same field? Sixth, I wonder if cost-effective searching might also lead legislatures to embrace global novelty. Currently in the EU, a prior design counts for the assessment of validity if it could be reasonably expected to come to the attention of the circles in the sector concerned operating within the EU. Such a test was aimed at removing from the validity assessment truly obscure designs and designs which had been forged. But is any design truly obscure if AI can find anything that's online in a world that is more and more played out digitally? If the person in the relevant sector circles can, with a few keystrokes, in fact find any design from anywhere in the world and indeed from any sector, then presumably national or regional novelty becomes untenable and the flexible exception for truly obscure designs will hardly ever be needed. Seventh, and finally, might rapid, inexpensive and accurate searching increase the likelihood of trolls and bullies? Non-practicing entities are well known in patent law. I've already mentioned the likelihood of AI generating millions of designs, but the cost of registering huge numbers of designs, even with the EU's discount for multiple designs filed at once, means that that sort of trolling may be less likely. But a design troll could emerge, threatening to invalidate valuable registered designs in the absence of, say, a payoff, having already identified quickly and expensively close prior designs. A design bully, on the other hand, might take a slightly different approach. They might identify a competitor's successful product, then search for an earlier design which creates the same overall impression on the informed user to purchase or to license exclusively, providing a post facto litigation tool to stop or slow down the competitor. Such conduct is not currently unlawful, although it seems edging towards an abuse of the IP system. Examples are already available from the world of trademarks, having lost in the High Court against an entity called Easy Life, the Easy Group company, which licenses various marks to third parties, including EasyJet, purchased some marks from what I will call a fourth party, and then used them to have another go at Easy Life. Again, any downside to good searching will be exacerbated by my first assumption, billions of available designs. My third assumption, perhaps most controversially, is that AI will play an increasing role in decision-making. I don't see AI replacing human judges in my working lifetime, although that somewhat depends if that stretches to 110 years. But I can see AI assisting decision makers, particularly in relation to some of the routine decisions. For example, at the UK IPO, are two signs confusingly similar? The two designs create the same overall impression on the informed user. I can see AI being helpful here in two primary ways. First, properly trained AI decision-making helps to remove bias. There have been many studies on judicial bias. Inessa Kolikova's study of 68,000 decisions of the Canadian Immigration and Review Board is an example. She found tribunal members varied significantly in their granting of asylum. For some tribunal members, the grant rate was as high as 90%, and for some, the grant rate was as low as 10%. As cases were randomly assigned to tribunal members, it would be statistically unlikely that one decision maker was getting almost exclusively meritorious applications and one was getting almost exclusively unmeritorious applications. A similar study of nearly 300,000 immigration decisions in the United States found that 208 judges varied from a grant rate as low as 10% to a high of 98%. Only bias can explain these variations. Some judges almost never sided with the immigrant, and at least one judge sided with the immigrant in 98% of fines. Currently, no similar statistics are available for decisions of the UK IPO, although the proprietary website Solomonic has started preparing some statistics for Chancery Division judges. AI trained on biased material will be similarly biased, but AI trained, for example, on all 68,000 Canadian immigration decisions should iron out the disparity between the grantors of asylum in 10% of cases and those granting asylum in 90% of cases. Removing bias is a good thing in and of itself. Similarly, greater predictability of tribunal decisions reduces litigation and therefore the costs of doing business. The second advantage to AI in decision-making is speed. Imagine a UK IPO hearing officer or a judge who has not only read all the evidence and submissions in the case, but has also read every decision ever made under the relevant statute and is able instantly and without bias to generate a reasoned decision on whether two designs create the same overall impression on the informed user. For my part, I would prefer the case still to be heard by a human tribunal, and for the human to review and make sure she or he agrees with the decision that's been generated by the technology. But if justice delayed is justice denied, there are many advantages to a decision rendered within a week, rather than the current 12 to 18-month delay at the UK IPO. Users of the system will know more rapidly where they stand. I would still retain an appeal to someone I'm going to rename as the Lord Chancellor's appointed human, and perhaps the nature of the appeal has to change. Currently, appeals are only available on errors of law or principle, but the black box of AI decision-making makes that somewhat difficult, so maybe appeals need to be de novo. But greater speed and lower costs will be attractive to many users of the system. I did not today wish to emulate either Henny Penny or her Panglossian opposite. Rather, I have put forward for discussion some potential outcomes based on 3 assumptions. Whilst you are very welcome to challenge my suggested outcomes, it does seem to me that my 3 assumptions are very close already to reality. There are many positive ways in which the technology can be harnessed in the interests of designers, both large and small, and of the system itself.